Okay, hello everyone. Welcome to the panel to discuss the recent United States Supreme Court decision on whether or not Title VII applies to the LGBT community. And we're happy to report that the Supreme Court said, yes, it does. And we really have one of the most momentous Supreme Court opinions for LGBT rights probably that we've ever had. And we've got a great panel to talk about it today. For those of you who are attorneys and who are getting continuing legal education credit, here's the CLE number. I'll hold it up for just a minute. And we will put that CLE number up again before the program is over with, combining low tech with high tech. Also, anyone wanting to ask questions, if you could just send your questions in to info@austinlgbtchamber.com, and we'll try to get to your questions as well. I'd like to begin by introducing the panel. With us today is Shelley Skeen. She is an attorney with Lambda Legal. She's a former chair of the LGBT law section of the State Bar of Texas. Lambda Legal is a leader in what's called impact litigation. Lambda Legal looks to file lawsuits that will make a difference in furthering the civil rights of the LGBT community. Lambda Legal was actually involved in one of the underlying cases that went up to the Supreme Court that we'll be talking about today. And Shelley's going to be talking with us about what it is that the Supreme Court recently did. Also with us is Bob Schmidt with the Cruz Law Firm. He is a longtime employment lawyer, and I'm sure as excited as anyone that all of a sudden he has a new tool in his arsenal in representing LGBT employees who are experiencing employment discrimination. Robert Schmidt was named a super lawyer in labor and employment law and is well versed in the issues we'll be talking about today. Also today with us is Ricardo Martinez, the CEO of Equality Texas. He is involved with Equality Texas, leading the advocacy organization, which is instrumental in working with the Texas legislature as laws are being passed affecting the LGBT community. He's going to talk to us about the impact of the recent Supreme Court ruling and how that might affect upcoming legislative landscape, and to also talk about what next. When I talk about what next, we can't understate the importance of what the United States Supreme Court just did. Employment non-discrimination has long been the holy grail of the LGBT civil rights movement. Back in April of 1953, President Eisenhower signed Executive Order 10450, which banned homosexuals from employment in the government. And you can't understate the significance of that. The federal government could not hire LGBT people. You couldn't be a postman, you couldn't be a forest ranger, you certainly couldn't be in the military. Well, if the federal government wasn't going to hire homosexuals, well, then of course, corporate America would follow suit. And being found out to be an LGBT person cost you your job. Well, how did that impact people coming out of the closet? It kept people in the closet. If you thought coming out of the closet would cause you to lose your job, it's hard to think of a more impactful societal cause for people being in the closet. So advocates back in the 50s and even before then thought we have got to get employment non-discrimination. Gay and lesbian and transgender people cannot be in fear of losing their jobs for who they are. And all sorts of advocates have worked forever to try to get employment non-discrimination. Well, then a few years ago, we all of a sudden had the issue of same-sex marriage come up. And a lot of the advocates said, let's not go with same-sex marriage. We'll never get that. Let's keep our eye on the prize, which is employment non-discrimination. Well, all of a sudden, same-sex marriage leapfrogged ahead. We had same-sex marriage, but we still didn't have employment non-discrimination. And now, thanks to the Supreme Court's ruling in Bostock last week, we finally, for the first time, have nationwide employment non-discrimination rights. This is huge for the LGBT community. This is what advocates have been working for a generation, and we have it now. And it's huge. It's a big deal. And with that, I'm going to turn it on to over to Shelley Skeen, attorney with Lambda Legal. And Shelley, could you go ahead and tell us what did the Supreme Court do? What was the Bostic opinion, and what just happened?
Sure, I'll try, and I'm going to ask all of my awesome colleagues here to jump in if I miss something. But I think it was a couple things just to set some context. There are about 8.1 million LGBT workers in the United States right now. And of those folks, less than half of them are covered by non-discrimination laws state in their employment. And so what Title VII does, which is what this case was about, is it prohibits discrimination in employment if you are an employer that has more than 15 employees. So I do think that this is the holy grail. I know that Gary's been working towards that for a long time, as have many of us. But I think it's also really important to understand that of the employers, only about 20% have more than 15 employees. So that means for the other 80% of employers in this country, they're not going to be covered by this decision, which is why, as we talk further through this today, why it's so important that you push, at least in our state, in Texas, for employment non-discrimination laws, and more broadly, non-discrimination laws in housing, in public accommodations, in healthcare, which we'll also talk about the Equality Act. So just to set the stage, in Texas, why is this so important for LGBT folks? In our state, we've got about 1 million LGBT folks, which is about 4.1% of our population. And of those folks, fully 26% of them do not have health insurance. 27% of them are food insecure, and 26% of them make less than $24,000 a year. So think about that. And then if you put our transgender Texans in to that mix too, it's worse. So for those folks, 17% of them don't have a job, and 34% of them live in poverty. So what did the cases do? What does Title VII say? Title VII says that employers cannot discriminate against you in the terms, conditions, privileges of your employment. Terms, conditions, compensation, and privileges of your employment. So if an employer fires you, refuses to hire you, or fails to promote you, or in some way treats you differently than someone else based on your sex, your race, your color, national origin, and that's the way the law was written back in 1964, then an employer cannot do that. And so the question before the court in the cases, this was 3 cases, 2 involved sexual orientation and 1 involved gender identity. And the question before the court is, or was, does that term sex in Title VII include sexual orientation and gender identity? And so for many years, folks who, based on their gender identity, because of a case that came out in 1989 called Price Waterhouse versus Hopkins, folks who did not match their gender stereotypes. So for example, maybe it was a woman who was not so feminine, or maybe it was a man who was, well, we'll just say for the purposes of this, sex stereotypes, the way a man should act or the way a woman should act, was found to be protected under the Price Waterhouse case. Despite that, folks who were based on their sexual orientation or gender identity the courts really struggled with that. So jumping to where we are now, the purpose of Title VII, the purpose of the statute was for folks to be looked at based on how they do their job, and also to be hired, not because of their race or their religion, but to be hired on merit. So really, Title VII was meant to take out everything that would be a hindrance to your ability to do your job well. And that's why, given our makeup in our state, why you see this being so important, especially for folks who are not making that much money, even though it only covers big employers. So what happened before the court is, in essence, in the 3 consolidated cases, and I'll come back and I'll talk about that real quick because I don't want to talk too much, but in the 3 cases, it was looking dicey. We've all been watching the court since pretty much January, because these cases were argued back in October. But the court came down and said, yes, the word sex encompasses sexual orientation and gender identity, because those things, you can't think about somebody's sex without thinking about who do they have an enduring romantic relationship to, based on sexual orientation, or if they're assigned a sex at birth and they want to transition to the sex that they have always been, or to the gender that they have always been, then you're taking into account sex. And so,
Shelley,
yeah,
if I could, just let me quote from the case, because the court couldn't say it any clearer. In the Mange opinion, Judge Gorsuch said, quote, "For an employer to discriminate against employees for being homosexual or transgender, the employer must intentionally discriminate against individual men and women in part because of sex. That has always been prohibited by Title VII's plain terms, and that should be the end of the analysis."
right. And so that's what happened. I'm not gonna, if y'all want to hear about the facts of each case, I can kind of tell you what those were. But, well, let me briefly tell you
Yeah,
what
it's
those were.
interesting.
Sure. So one of the cases involved gender identity, and it involved a gal. Her name was Amy Stevens. She worked as a funeral director at a funeral home. She had had this job for about 6 years, and she decided that she had always been a woman. And so what she did is she told her employer, hey, I'm going to go on vacation. And when I come back, I'm going to be presenting as a woman, and I want you to call me by my name, which is Amy. And the employer said, not so much, you're fired. And so that's the gender identity case. And Amy Stevens, actually didn't get to see the case come down. She passed away on March the 12th. So she was a pioneer without even knowing that she was a pioneer. And then the other 2 cases involved sexual orientation, and one involved a gentleman named Gerald Bostick, who worked for Clayton County in Georgia, and he was a child welfare advocate. And he worked for the county for 10 years. The county won national awards. He won awards. He got the most uptake of kids in the county ever. And he joined a gay softball league, and he started talking to people at work about that. And then he got fired shortly thereafter, despite the fact that the county itself had won many awards under his work and as a result of his leadership. And then the other case was Zarda versus Altitude Express. And that was a case out of New York State, I'm going to say the Second Circuit. And in that particular case, we had a gentleman who was a skydive instructor, and you're strapped to people when you're a skydive instructor, and he was strapped to a gal, and he said to her, hey, don't worry, not a big deal, I'm gay. And so what she did is she accused him of fondling her, which seems kind of antithetical to being gay, but in any event, he was fired shortly thereafter, and he also passed away in a skydiving accident in 2014. So he didn't get to see this. But so these are real people with real lives just doing their thing. And so we all should be on an equal playing field. And I'll be quiet.
Don't you think what was particularly helpful about the 3 cases that led up to the Supreme Court's decision was because in each of the firing decisions, there was no question that the reason these individuals were fired is because they were gay or transgender. I mean, the court didn't have to wrestle with, well, was there some other reason that would have justified these firings? It was undisputed before the Supreme Court that the sole reason these individuals were fired was because they were gay or transgender.
So I'm going to disagree with you a little bit.
Okay.
Little bit of pushback on that. So Gerald Bostick was accused of allegedly taking funds that were county funds. I want to say it was something like $77. It wasn't very much money. But the key to the case and the key to prior cases is that if the employer takes into account just one of the reasons that they don't promote you, fire you, or don't hire you is your sex. It can be just a little bit. That's enough to be prohibited under the statute. Now, Bob's going to talk about this a little bit more. And the court looked at what's called but-for causation, which means that if the employer had not taken your sex into account in firing you, then if you compared that to somebody else, you would have a different result. So I'm not really saying that easy, but the bottom line is, was that a reason that you were fired, sex? Sure. If it was, then that's enough. So that's a little bit of a pushback. Does that make sense?
Yeah, yeah. Although, and Bob, you're going to be talking about this some, because every time you have one of these cases, the employer frequently will say, well, yes, the person may have been gay, but that wasn't the real reason I fired him. I fired him for this other reason.
Exactly. Yeah, we'll talk about that. I was going to say, in this case, Shelley, wasn't it that the employers in these cases did not give up the argument that, hey, we have the right to fire these people because they are gay or transgender. So that's one of the, if they maybe had taken a different approach. Anyway, the employers are in part due to why we got this case to the Supreme Court.
Right. I think what Bob is saying is that the employers were saying, look, in the statute itself, you see the words race, religion, color, national origin, and sex. You don't see the words gender identity and sexual orientation. And because you don't see those words in the statute, that's not what Congress meant to protect. But if you look at the history of the statute itself, over time, it has been broadened to make sure that really people are looked at based on merit, not on their sex. And I won't go into all the history. And I think even Justice Scalia in a case called On Call, or I'm going to call it On Call, came out in 1998. He said statutory prohibitions often go beyond the principal evil that they were meant to cover reasonably comparable evils. And it's not the principal concerns of the legislators by which we are governed, but it's the law. And so you look at the plain meaning of the law. Does the word sex include, do you have to, sexual orientation and gender identity? Does that include sex? Sure, it does. So that's what Justice Gorsuch said. That's what the majority opinion says. And we had a 6-3 opinion, which I think a lot of folks were really grateful about, because we also got Justice Roberts. And if you read the opinion, I think there's some really great language for LGBT folks in the opinion by Gorsuch, where he's talking about the respect that we deserve just like everyone else. And that because we're a disfavored group, that shouldn't be a reason why a law should not apply to us. And we're past that point. So I think that's some really, really good language. Some bad language is towards the end of the opinion, where he talks about religious liberties. He talks about the federal religious reformation, religious freedom. I can't even say it right now. The RFRA. He talks about RFRA, which a little bit, he says it's a super statute. So the bottom line there, not to make it complicated, is that there could be pushback based on religious beliefs by employers for hiring people who are gay or transgender. So
Shelley,
make it
what
simple.
is the significance, do you think, that Gorsuch, a Trump appointed Supreme Court justice, is the one who actually drafted this opinion, and that it was joined in by conservative Roberts? What is the significance of that, do you believe, in terms of Supreme Court jurisprudence?
Well, I think that what they did is, I think what we saw was some really, really great lawyering. And this has been really, really good lawyering. These are cases that Lambda started bringing back in, 2005, 2011. And I think that what the court did, what Gorsuch did, and what Roberts did, is they looked at the language And statutes, you always look at the plain language of the statute, because regular people are supposed to be able to read the statute and know what it means. And so the plain language of the statute says sex, and that is a conservative viewpoint. Sexual orientation and gender identity fall within sex. And so I think it's an opening because of some of the other language in the opinion, which I do think is very honoring of LGBTQ people. Even Justice Kavanaugh's dissent, there were 2 dissents. Alito is mad. He's mad as heck. He's not going to take it anymore, but he did give us a nice little roadmap for where the word sex is used throughout the statutes: housing, education, and so forth. So that's helpful. He gave us a roadmap for where we need to go and make sure that the word sex is still interpreted to include sexual orientation and gender identity. But even Justice Kavanaugh talks about the fight that the LGBT community has gone through to get the rights that they have. And he just thinks that the way that the court did it in this case was not looking at the plain language of the statute.
And Shelley, if you don't mind, let me read just briefly what Justice Kavanaugh said, because I've never seen anything like this before. Kavanaugh basically said, well, I think the court should have ruled against the LGBT people on these technical kinds of reasons, but notwithstanding that, for no apparent reason at all, at the end of his opinion, Justice Kavanaugh says this. He says, quote, "It is appropriate to acknowledge the important victory achieved today by gay and lesbian Americans. Millions of gay and lesbian Americans have worked hard for many decades to achieve equal treatment in fact and in law. They've exhibited extraordinary vision, tenacity, and grit, battling often steep odds in the legislative and judicial arenas, not to mention in their daily lives. They have advanced powerful policy arguments and can take pride in today's result." Would you ever imagine anything like that from Justice Kavanaugh, an opinion about LGBT people?
Well, I think, he was a softball coach for a women's softball team. Not that I'm going into any kind of stereotypes.
Gender stereotypes there.
And I also, he was a clerk. He clerked under Justice Kennedy. And so, as did Gorsuch. So we've got a couple of justices here who probably lie a little bit more on the, at least from a social standpoint, they wouldn't apply the law that way. But from a social standpoint, I think they want to be able to find ways to make sure that everyone is seen and heard.
And Shelley, one of the things, when we had these programs prior to the decision, there was a lot of concern expressed that the court might try to treat the transgender community different than the gay and lesbian community, and they might try to have one set of rules that maybe they wouldn't be as favorable towards in the transgender case as they were in the other cases. But the court didn't do that at all. This opinion applies just as fairly and just as equally to the transgender community as it does to the gay community or lesbian community. What do you think the significance of that is?
Well, again, I think the judges, here's a great quote. Let me give you a great quote. This is, well, by the way, my favorite page of the opinion, if anybody wants to geek out, is page 9. But this is on page 33. And I think this is what the court did. It said, "Ours is a society of written laws. Judges are not free to overlook plain statutory commands on the strength of nothing more than suppositions about intention or guesswork about expectations," talking about what was the case when the law was passed. Can you imagine if we looked at a law that was passed in 1879 and we tried to figure out what folks were thinking when they passed it? You have to be able to rely on the language of the statute. So I think the opinion, frankly, from that point was very, very well written. And I think that this particular case is going to be looked at in scholarly areas across the board because of the way it was written. And it was really just sort of a battle between 3 different views of what's called textualism, which we won't get into, but it's really just looking at the plain language of the statute. And so Kavanaugh thought you should look at it one way. Justice Alito thought you should bring in context. And Justice Gorsuch said the words say what they say. And that was as the result of really good lawyering, because basically what the lawyers did is said, how can we pitch this to the court in a way that they can hear it so that we are protected? And that was a very comprehensive, well thought out, over many, many years strategy, starting, like I said, back in 2005, 2011, 2017, and to where we are today.
Yeah, and thank you so much, Shelley, and all the lawyers at Lambda Legal, because this is a game of like 3D chess in terms of having to structure these arguments to get them to the Supreme Court where you ultimately get the result that you wanted. And the advocates at Lambda Legal and other advocacy organizations and lawyers who worked on these cases were brilliant lawyers, and that brilliance has gotten us this result that we're also happy with today. Now that we have this result, Bob.
It takes a village. I'm just saying, it takes all of us.
Now that we have this result, Bob, we've got the Supreme Court saying, yes, LGBT people can avail themselves of the Title VII protections. So now the million-dollar question, there's an LGBT employee working for some employer, and that employee believes that they have been fired or that some non-favorable employment decision has been made against them because they are LGBT. What can they do? What do they do? How does this process work now?
Right. Well, I'll answer that question, but I do just want to just comment on how, spectacular this decision is and how big it is, because for years, when an LGBT employee like what you just described would call my office and would say, hey, I've been fired and it's because I'm gay, and they would give me, circumstances like that, I would have to say, we don't have that law in Texas. And I really, we'd have to struggle. And we worked on ways to kind of help. We used the Price Waterhouse decision that Shelley was talking about to try to bootstrap, basically put in things like gender stereotypes. Well, maybe you weren't fired because you were gay. Maybe it was because they didn't like the gender stereotype that you fit in. Same thing with transgendered employees. And so, we would work to try to do it, but it was never going to, just to be honest, like in the day-to-day real world, it was hard to imagine a real person getting real compensation, getting real justice the way the laws were before. There's a few exceptional, noteworthy results here and there that came around, but for the most part, it was really hard. We were working with our hands tied behind our back. And so now that has changed. And so now, I was thinking about this because we talked about it, because it's also relates to businesses and how they, are going to be affected by this decision. But I think for regular gay and transgendered people, this is huge. And now there actually is a remedy, which is fantastic. And just to give you kind of the nuts and bolts of, well, what do I do if I think that I was discriminated against or treated badly because of my sexual orientation or a gender identity, those kinds of issues? What do you do? The million-dollar question. And there is a long, I was going to say this is big changes for employees, but not necessarily for employers, because there's a long history going back to the 60s. The civil rights law prescribes, it has this basic way it's implemented. And the first thing you got to do is you file something called a charge of discrimination. And that's filed with the EEOC. There's also state agencies and some city agencies too that can accept a charge of discrimination. I say the EEOC, that's the Equal Employment Opportunity Commission. And there's offices in various big cities in Texas.
Is that a form you can get online? Is that?
Yeah, there's forms that you can get online. I will tell you, just as a lawyer working in this area every day, if somebody has had something serious that happened to them and they feel like a firing, for example, or something, that's a big deal, there are attorneys out there like myself who are trying to help in these kinds of situations. And you can certainly go online. It's free to file these charges of discrimination, but most lawyers, including myself, we like to work with people from the very beginning. And so if you find that you got you were terminated and you feel like it was because you were gay or lesbian or whatever the category, transgender, now you can actually reach out to employee side employment attorneys, and they will be interested in your situation to try to help you. And I'll talk a little bit more about why and how and under what circumstances. But yes, you can go for free online to either to the EEOC, and they usually will do an interview if you can get to a real person. Sometimes these agencies are tough to get through, but they usually do interviews. They will actually write up what your situation is and put it into this charge of discrimination. And the law says you have to do that before you can bring a lawsuit. Another big thing to point out in this area is that this is one of the areas where in the legal world for non-lawyers, that's something that most people have heard about called statutes of limitation, but that's a deadline that you got to take action by. And one of the big deals in employment law is we have pretty short deadlines or statutes of limitation to take action. And under state law, and we'll talk a little bit more about that, but under state law, it's 180 days or roughly 6 months. And under federal law, it's 300 days. So from whenever the bad thing happens to you, if you got fired, if you got demoted, I can talk a little more about hostile work environment too. But whenever there's a bad thing that happens to you at work, the fancy employment law term is adverse employment action. You have to act pretty quickly. You can't wait for years to do that. And so, but you file a charge of discrimination, it's reviewed by the EEOC, and then at that point, if it hasn't been resolved, then you can actually go to court and bring a lawsuit. But I guess I wanted to jump, Gary, I mean, if I can go ahead and just, one of the things that you mentioned kind of stuck out to me, which is, so a person believes that they were terminated because of their sexual orientation or their gender identity. But of course, the company, rarely do companies say that. Occasionally we have that happen. And I think honestly, LGBTQ areas are one of the few areas where still in Texas, there are some people who are probably proud to say, there are people who are proud to say, I fired that person because I don't believe in that way of life, or whatever you want to call it. But most of the time that doesn't happen. And so one of the things that, and I may be kind of going into a little bit of a different direction, but how do you prove that you were terminated because of your sexual orientation or of your gender identity? And so I'm just going to talk a little bit about that, because there's some basic ways that courts have recognized. I mean, the first one is, do they actually say things? Is there something, we call it direct evidence? Is there direct evidence that they don't like that person because of, in the old day, prior to this decision, because of their race? They don't like them because of their sex. They don't like them because of their age or disability. Well, now you can add into, is there any sort of direct language that the employer or the boss or the coworkers used that suggests they don't like somebody because of their sexual orientation or because of their gender identity? And again, in this world and in this state, I think it's one of the few areas where a lot of times people could get away with making jokes about gay people, making jokes about transgender people. And one of the things that made me the happiest about this decision is I know a law doesn't change things overnight, but now if an employer hears that kind of talk going on, they actually have a real legal reason to shut that kind of stuff down. And hopefully that will we still have people making racist and sexist discussions at work, and those laws have been in effect for a long time. So it's a long-term thing. But direct evidence would include, I don't like gays. I don't like transgender people, or making jokes about it or snickering about it. Typically, if it's done by a decision maker, somebody who's responsible for the decision, then that is some really powerful evidence. But most of the time, courts recognize that we don't have that in employment law cases. Most of the time, employers are smart enough to, use different wording, couch their decisions in different ways, their employment decisions in different ways, so that you rarely do have somebody overtly saying something discriminatory. But courts recognize, hey, discrimination absolutely still does go on. And so how do we show that there's discrimination in these kinds of cases. And the first way, Ricardo, were you saying something?
Yeah, I just wanted to raise my hand quickly because
Yeah.
as someone who filed a complaint when I lived in New York and had to go through the process of doing all of this, as someone who had the burden of proof to provide documentation, I would offer that emails are a great way to codify and to track incidences, right? When I learned that my situation was a pattern of behavior, I began to document everything via email to both coworkers and my supervisor, right? So in the process of seeking legal counsel, I made sure that everything was tracked. And even though it was ultimately, there wasn't sufficient evidence, right? So I just wanted to offer that really quick.
Yeah, no, absolutely. And you know, emails, text messages, all of those things, if somebody sent, you know, it ranges from just on the discriminatory language. If somebody has sent an email around, you know, making a joke about LGBTQ people, or if there's text messages where they're making jokes about that, that's absolutely direct evidence. On the other hand, it's really good if an employee can show that they are a good employee and they've got emails, they've got text messages. You know, my favorite kind of case to come into my office is when somebody always acts professional and you see their email, you know, their boss says, hey, I need this project done. And the employee says, here you go. What can I do? How can I get it for you? And they have a good, those emails now become number one evidence in these kind of cases. So showing that you did your job, showing that you were good at your job, creating an email record just by your day-to-day work that you're a good employee is going to be a huge help in these kind of cases. And that's really like number one is what employers do is they will say, I didn't fire this person because they are gay or a lesbian or black or white or whatever the category is, or woman. I fired them because, and they typically then will give a situation about why this employee was a bad employee. And so number one way that we, in the legal world, we call it pretext. We try to show that that decision that was made and the explanation that's being offered by an employer is false or pretextual. And it's basically the logic behind it, which I love. There's a good case out there that talks about this, but it's that if somebody is firing somebody for a real reason, if they're telling the truth about it, great. But if they are making up a reason, if they are not telling the truth about why they are firing that person, there's a good likelihood that they're lying about it to cover up an illegal reason. And so if, like a perfect easy example is if somebody comes in, they fire somebody claiming that they came in late. They fire a gay or transgender person saying, you know, you were late, but you can prove, hey, I wasn't late. Here's my time clock when I came in. That means that they're making this reason up and it's false or pretextual. So that's the number one way, or the first starting point that we look at is, can the employer back up their reason for why they terminated them, or can we show that that reason is really a lie or is false or pretextual? And so that's, and it is that case in 99.9% of the cases I have, is that they're going to give some reason for it. And we then go about and look and say, how can we show that this reason is false? Another way that you can show discrimination, even if, I mean, again, we start making check marks and how many things can we get in our case to show. But another way is, are they treating this person differently than they treat other people? So going with my same example, if they claim that they fired this person because they came in late, can we show that there are 20 other employees in the same general category who also come in late and they don't get fired? So even if the reason is true, technically, yeah, I came in late, but there are plenty of straight people who come in late, but they don't get fired. There are plenty of, you know, regular, non-trans, gender identifying people who come in late, but they don't get fired. That's another way to show that the reason that's being offered is false or pretextual. So those are some of the things that we look at. Another thing that was really nice in all of these cases, I believe, and Shelley, you can correct me, but in the Bostock case and the Zarda and then the Amy, I'm blanking out on her last name, but in the funeral home case, is that the terminations took place really close in time to when these individuals came out or when they were exposed to, let their employer know, hey, I'm gay or I'm transgender. And closeness in time from when an employer learns about a situation, learns that you're transgender, learns that you're gay, that is another piece of evidence that can be thrown in there. That in and of itself, there's a lot of case law that says closeness in time isn't enough. But if you start, again, we just start kind of going through the record and try to put together bits and pieces of evidence to help build a case and to help show that these guys are not telling the truth. The employer is not telling the truth about why they fired this person.
Now, we've had several people send in questions asking or pointing out that the Supreme Court in this case last week didn't create some common law right that, oh, you can't fire gay people. It's just a general principle of the law. What the court did was they took a statute, a law passed by the legislature, and say, we're going to apply this law favorably to LGBTQ people. So there's still a law on the books that needs to be interpreted, but if the law's on the books, the law could be taken off the books, and that's a risk that would run out there. And also, I think, as both Shelley and Bob, as you've mentioned, this federal law that the Supreme Court interpreted doesn't apply to everybody. So it seems like there's still advocacy work out there to do to sort of broaden the types of laws that the Supreme Court said could be applied to LGBT people. And Ricardo, is that part of what Equality Texas is going to be looking at this next legislative session?
Yeah, of course. But before I go on to talk about just like what is coming up next, I wanted to kind of go back to the reasons that were stated about why this decision was important, right? I think when you have been involved in advocacy work for a really long time as an activist or as a volunteer, I think, it's incredibly important that we have milestones that give us hope, right? And 2020 has been incredibly difficult for a lot of people. And coming into that decision on Monday morning, we had just a couple of days before received the notice that the Department of Health and Human Services had released a new rule, which would create a license to discriminate, right? Inviting healthcare workers, doctors, hospitals, health insurance companies to any of those that receive federal funding to refuse to provide or cover critical health services, right? That was hard, primarily on our transgender folks and family. We were celebrating or commemorating the 4th anniversary of Pulse. And we were recovering from learning about the murders of Dominique Remy Falls and Rhea Milton, the 2 Black transgender women who were murdered in Pennsylvania and Ohio, right? So Monday morning, I knew was a chance that the opinion would come down, and I didn't want it to, right? Part of me didn't want me to, because I was, not that I was expecting a negative outcome, right? I always will look at the positive side of all things. So I was expecting for an encouraging decision, right? But I didn't want it that day, because everything felt so mournful that weekend, right? And people needed some time to recover. And I think we cannot overlook the importance of hope when we are sustaining a movement, right? And I think what this decision did for a lot of folks is give some hope. You add on top of that last week's Thursday decision with DACA, and people are seeing, at least hopefully, it's true for me, and let me just speak for myself, are feeling some momentum on the positive side of things, right? And that is incredibly powerful.
Can I just say, I mean, we kind of talked about it a little bit before we got online, but that morning when that decision came out, I mean, I remember hearing about it and just so excited. I think I emailed you guys, and I was emailing and texting friends. I mean, I unfortunately am a little less, I wouldn't say I'm pessimistic, but I've just seen so many, I try to prepare myself for negative things. And so I'm not just devastated, and I really was not expecting it to go our way. And so I was so happy.
And I was expecting a split the baby kind of opinion,
yeah.
or there would be, bad language for the transgender community, but it wasn't. The complete victory just had me floored and excited. What about you, Shelley? What was your reaction when you read the opinion?
So we're in the process of moving. And so my partner was over at the other place and maybe an hour later came home. And so she came in the door and I had just gotten off another phone call. And so I went out the door and we just screamed, just absolutely screamed. And I think Ricardo's right though. We need the hope. And I'll also say, just a quick plug for Lambda. So here's my quick plug. So we filed a lawsuit today against the law that would roll back the protections. It's Section 1557 of Obamacare, or the healthcare rule, that says this is just a rule that the executive has said, now we're not going to apply healthcare equally to people who are LGBT. We're not going to do gender affirming healthcare. And so we just filed a lawsuit today on behalf us and several organizations. So we're challenging that law. And now we're able to challenge that law, or challenge the rule, should I say, based on the Supreme Court's decision, because it was so favorable. So that's going to be very, very helpful, because the rule uses the term sex and says you cannot discriminate on the basis of sex.
Well, and Ricardo,
Yeah.
having this incredible ruling that really surprised all of us, given that it was a conservative court that held in favor of the LGBT community, and given that you had Gorsuch, a Trump appointee, actually author this opinion, will having something like this in hand help you have a little momentum as you try to do your work here in Texas now?
Certainly. I think, again, going back to hope, right? I think people need that to be able to move forward, right? In the short term, because of this decision, we're going to be able to connect folks that are reaching out to Equality Texas seeking legal services or resources because they've been discriminated on in the last 6 months. And we're going to be able to then connect them to Lambda Legal's help desk, or have them fill out the ACLU intake form to connect them to the resources that they will need, right? So in the short term, we're expecting to receive at least an influx of inquiries related to, hey, that magic question that you asked Bob about, like, I've been discriminated against, what do I do, right? There are still some barriers to be able to do that, because in order to do that, again, the burden of proof is on you, but also seeking out pro bono resources for someone that may not be making enough to have legal resources is really difficult, right? But bottom line is that we still have a lot of work to do. Having the law on our side is super helpful. The clarification of the definition of sex to include sexual orientation and gender identity helps folks like Lambda and ACLU to be able to litigate cases to ensure that we are moving towards full equality, right? We in Texas don't have protections in public accommodations or healthcare, adoption, housing. And so one of our priorities for the 2021 legislative session for Equality Texas and our coalition partners is going to be to introduce a comprehensive non-discrimination bill. And Representative Jessica Gonzalez, the House Caucus, LGBT Caucus Vice Chair, has announced that she's going to author that. And so we're really excited about that. Moving forward, it is also important for our community to continue to engage, right? Equality Texas has committed and will continue to, for 30 plus years, to educate, engage, and mobilize people on behalf of LGBTQ equality. And so we're going to continue to advocate that our constituents continue to reach out to their federal representatives and senators, urging Congress to pass a non-discrimination law that would protect LGBTQ people in public accommodations, federal programs, and more. And then again, locally, we're going to continue to have those folks reach out to their Texas reps and senators, urging for the passage of that comprehensive non-discrimination law. And, again, continuing to support other movements and our community partners. We're going to continue to champion that our constituents, our members, if they can, if they are healthy and able to join the Pride for Black Lives Matter rallies that are happening in Houston and Dallas, to continue to do that work, because it's incredibly important for us to show up now more than ever, and continuing to address some of the questions that folks have, right? And I don't know if Shelley's going to touch on this, but some of the questions that we have gotten a lot of is, what implications does this have on the military ban, right? What implications does this ruling have on HHS and the rollbacks of Obamacare? And so we're going to continue to field those questions and connect folks to the resources that they need.
So I'll just chime in quickly. The Equality Act is federal legislation that was first introduced back in 2015. And what it would do is it would add sexual orientation and gender identity to the Civil Rights Act of 1964. And it would expand the places where there would be non-discrimination for all. And it would, so for example, housing, healthcare, education, employment, public accommodations, credit, so the credit that you can get, jury service, and also federal funding. So for example, right now, as a woman, I could go try to buy a car, Gary could go buy the same car, have the same credit score, but they could charge me a higher interest rate. And so that would stop that. It would also go towards healthcare, transportation, banks, and funeral services, and some of those things that LGBTQ folks need where we are discriminated against. So that's something that I really would implore all of y'all. That's the fix for a lot of the problems that we have, and the fact that only 20% of employers would be covered by Title VII.
And I guess going back, Bob, these employment non-discrimination acts that are pending in the United States Congress and in what Ricardo and Equality Texas is going to be working on in the Texas state legislature, don't you also need those additional tools as well?
Yeah, that's what I was going to talk about. So there is federal law, and it covers everybody in the nation. But then there's also state and some local laws as well. And in Texas, we have a law that is very similar to Title VII. It's called the Texas Commission on Human Rights Act, and it essentially mirrors what is in the federal law. But at this point in time, this is a very new decision. I mean, I think if the state judges would interpret, there's plenty of precedent out there saying that the state law follows the federal law, and it's based on the federal law. And so federal interpretations should be imported, if you will, into how we interpret state law. But I have seen, and Shelley and everybody, Rick, have certainly seen how there's a lot of hostility to LGBT causes in Texas state courts. And so until that is really codified, or the state legislature acts, there's going to be a lot of unknown questions. And so absolutely getting your state and local officials to adopt non-discrimination type language is going to be huge, because it's right now we don't know. And there's a lot of benefits, by the way, to being in state court. A lot of times you don't want to go to federal court if you don't have to. You get better jury verdicts, better jury opportunity for voir dire, some things like that you get in state court. You don't have to have a unanimous jury in a state civil court, whereas you do in a federal court. So it's a lot of reasons why we'd want to bring cases in state court if we can. And that's still an unknown as to what's going to happen. I think if a court is looking at it objectively and without a bias, the language, because of sex, the Supreme Court has now held that includes sexual orientation and gender identity. So it should follow, but is it a guarantee? No, not at all. So that's another
That's a
issue.
case that legal question you expect will be in front of the Texas Supreme Court at some point in the future now.
Yeah, absolutely.
Whether or not the United States Supreme Court's interpretation of sex should be something that the Texas Supreme Court should follow.
Exactly.
And even though they probably should as a legal matter, we're in Texas and who knows, huh?
Right. Even like on the Obergefell decision, there's been a lot of reluctance on the part of the Texas Supreme Court to enforce it. And of course, we have an elected Texas Supreme Court, and that makes these elections very, very important. to when you're voting on judges, to find out which judges. I mean, it really does impact everyone's real life, how these decisions, how we get these judges and what they do. It totally, I do this every day, and it impacts real people in real ways that you don't really realize. So yeah, it's very important.
And I would hope that is sort of the takeaway from this discussion, is that we can't go to sleep now. That I remember after Obergefell came down and we had same-sex marriage, a lot of people in the advocacy movement were like, oh, we're done. We got these great rights. There's not, and everybody's like, wait a minute, we still need employment non-discrimination. Well, now we largely have a huge favorable ruling for employment non-discrimination, but we still can't go to sleep. It's still not time to rest. This has been a great victory, as Justice Kavanaugh described it, something we can be very proud of. It creates a lot of momentum, but there is still a whole lot of work that needs to be done yet to
Do you mind if I ask
LGBT
something, Gary?
people the same rights.
So I was reading a Houston Chronicle article that featured Fran Watson, a Houston municipal judge, who had talked about how after marriage equality passed, people were like, but I can go to work tomorrow and be fired, right? It is incremental. This work is incremental. We have now gotten employment, right? We're moving in the right direction, but I can still go to a grocery store. I can still go to a hotel. I can still go to a hospital and be denied services, right? And that is precisely why we can't sleep, right? Although we are incrementally making gains, it is important for us to continue to show up. And what is most important is people's stories, right? Because I don't know who mentioned this, whether it was Bob or Gary or Shelley, but I believe wholeheartedly that what changes hearts and minds here in Texas and all across the country is having lawmakers understand how these laws trickle down to people, to everyday people, right? And so we have to humanize these negative bills. And we know for sure that in the next legislative session, we're going to see between 25 and 30 anti-LGBTQ bills, right? Looking at history, the last two legislative sessions, 62 anti-LGBTQ bills have been introduced. Not only will we have to kill all of those things, but we'll have to work twice as hard to proactively gain in any of these areas, right? So I encourage anyone who is galvanized and jazzed up and hopeful about the last week and a half to join Equality Texas, to share your story. I know it takes a lot of bravery to do so, but I think Amy Stevens was really brave in being able to do this, right? And so were the other plaintiffs. And I think it takes people to show up and be vocal and contribute by providing testimony, whether it's in person come January or whether it remains somewhat virtual. I think those things make the biggest difference. So whoever's watching, if you would like to share your story, if you'd like to provide compelling testimony, we would love to partner with you in doing so.
I think we're pretty much to the end of the hour. So we had like an hour panel set. We pretty much filled up our hour. At the very end here, I would like to give Elliot Beck just to say a couple words on behalf of the LGBT law section. And then Stephanie, if you could come in and say a couple of words on behalf of the Austin LGBT Chamber.
Oh, you're muted.
I did exactly what I warned everybody else not to do.
Okay.
As a co-host and co-sponsor of this event, and as chair of the LGBT law section of the State Bar of Texas, I just really wanted to thank everybody who has participated and viewed on YouTube, and especially Bob, Shelley, and Ricardo. Thank you so much, not only for being here today, but what I hope a lot of our viewers understand is that the folks that you're hearing from today are working tirelessly, often not being paid for what they're doing, day in and day out, endless hours. I've never seen people work as hard as the folks we've gotten to hear from today. So thank you. And Gary Schumann, he is a fantastic, endless energy an organizer and advocate for the LGBT community in the state of Texas and nationally. A lot of what has happened today was kind of his idea and brain baby, if you will. So again, thank you so much. Thank you for allowing the LGBT law section of the State Bar of Texas to be involved and to be a co-sponsor. We were thrilled to see what the Supreme Court did last week, and we're really excited to see what happens going forward, led by all of your fantastic work. So thanks again.
Thank you, Elliot. Stephanie, you say a few words on behalf of the Austin Chamber?
Thank you guys so much for being here with us today. We were so excited to get to do this with all of you. I'm Stephanie Pelletier with the Austin LGBT Chamber of Commerce. We are the local LGBT chamber here in Austin. If you guys need anything, let us know. We are taking questions still. Patrick, did you guys get all of the questions?
Yeah,
Gary?
I think we have. I've tried to answer several of them, but even though we're sort of our hour is done, if y'all guys just have a couple extra minutes, I wouldn't mind just chit-chatting a little bit more about this, because I have a couple of questions for y'all myself. And just if anybody else wants to hang on and continue watching, they're more than welcome, just for a little bit longer here.
Thank you again, everyone, for the questions, and we will make sure that they get posted online and that we get these videos posted online.
Before everybody leaves, if they're leaving at this point in time, I do want to make a plug for an organization that I've been involved with for many years called the Texas Employment Lawyers Association. It's a group of employee side lawyers who help working Texans who get in issues with their job. Many times these cases can be helped. They work on a contingency fee basis. And anyway, it's a great group. mytila.org is a good place. If you're in a situation, need employment law help, that's a good resource to have.
Well, here's a question that somebody asked that I think I love this question. The question is this decision retroactive? Because we had that with Obergefell when same-sex marriage was, all of a sudden, the prohibitions against same-sex marriage were found to be unconstitutional. Does that mean they were always unconstitutional? And the answer the courts have been coming up with is largely yes. And you have people who have been in same-sex common law marriages now going back decades. So sort of a similar situation here. Is there some retroactivity to this? If I lost my job 2 years ago and tried to file a claim because I was discriminated against as a gay man, can I now say, well, all of a sudden that claim is ripe? Can I bring the claim now? Or am I barred by limitations? Is there a retroactivity component to this?
Can I jump in? And Shelley, I'd love your thoughts too. But so one of the things that's going to make this tricky is that employment law cases have a short statute of limitations. You got to file this charge of discrimination within essentially 6 months or 9 months of 300 days or 180 days of when the bad thing happened. So if you were fired 2 years ago and you think it was because you were gay or transgender, it's pretty tricky to do that in this particular situation. There's all sorts of complicated issues around this, but if it's just sexual orientation or gender identity, that's going to be tricky. I do think the language, though, is broad in the sense that it applies to things that are happening today. And Shelley, I'd love your 2 cents on this too, but I think it does cover things that happened. If somebody was fired a month ago because of their sexual orientation or their gender identity, I think the Supreme Court decision is in that respect retroactive, or at least there's a very strong argument because the law didn't change. We're just recognizing what's already always been in the law. It's the word sex, and always is a part of sex. To make a decision firing somebody because they're LGBTQ means you're looking at their sex. So I think it is retroactive to the extent the statute of limitations haven't already passed, but that's a question that's to be answered. Shelley, do you have any thoughts on that? And you're muted, by the way. Oh, there you go.
Oh,
you're good.
Okay.
Now you're good.
So the short answer is no, because I didn't go research this. I can tell you different with Obergefell, right? Because the court specifically said that the laws, the same-sex marriage bans in all the states that still had them on the books, were unconstitutional. And so when you declare a law unconstitutional, it's void as if it didn't exist. And by the way, that's Justice Scalia and also Marbury versus Madison. But this is different. This is not the court saying the law itself is unconstitutional. This is the court saying, now we're going to read the law to include folks based on their sexual orientation and gender identity. So bottom line is, I have no clue.
And I know you're going to be involved in that litigation at some point in the future, Shelley. I could see you talking about this topic at a CLE a year from now. But here's a question for everybody. One of the viewers asked, what is the next big legal goal for the GLBTQ plus federal rights now that marriage and employment discrimination policies have largely been ruled upon? What would the next big question be? Stumped us. I think the next big question that's going to take up a lot of legislative space and a lot of court time is going to be, to what extent can people argue religious conviction to get out from under the obligations of these laws? And even in his opinion, Justice Gorsuch sort of concluded by saying, but I'm not going to answer the question as to the extent to which religious exemption issues might or may not be binding on some employer, almost inviting religious exemption cases and almost inviting employers to say, well, you know, my religious convictions give me an exception to these obligations to not discriminate. That's my guess, where we're going to see a lot of legal energy being spent in the coming couple of years. What are your thoughts?
So I don't know if Bob can talk to this maybe better than I can, but there are two cases pending before the Supreme Court right now that are looking at religious institutions and whether or not teachers fall within what's called the ministerial exception, which would mean that the religious organization could fire them. They don't have to, those religious organizations don't have to comply with, for example, Title VII or non-discrimination laws. And so, Bob, I don't know if you can talk more about those cases. I can talk generally about them, but you're probably much better than me.
Well, I can only talk generally about them too, but I think that it's been a long-running question and issue in Title VII and in the discrimination, employment discrimination world about what exemptions there are for religious institutions. And I think in this decision, by the way, they've broadened, or the one negative about this decision is it seems to be signaling even, you know, broader potential religious exemptions than just religious institutions. It's always been, I mean, for years, the courts have interpreted in what they call a ministerial exemption. So if a church is firing someone, that they can't, the Title VII laws don't allow that minister to then go in and say, hey, wait a second, I was fired, and for some violation of the law. Now there's cases that are pending that involve teachers in schools and in religious schools, and the question is, are they also covered by this ministerial exemption? What I always found maddening and interesting and frustrating is, in these cases, one of them was trying to bring a discrimination case, I believe, based on pregnancy discrimination, and it was a disability discrimination case.
And age.
Yeah, and age. And so basically, it's not just giving a right to a religious institution to discriminate based on religious views, which totally, you know, makes sense. If you're a church, you want to have someone who believes in your religious views, that they're a minister. But saying I can fire somebody because I don't like them because they're disabled, and I'm a church, so I can do that, or I can fire someone because I don't like them because they're older. Well, it's a very broad, you know, the ramifications are broad. And now with this reference to this Religious Freedom Restoration Act, it seemed to be inviting those kinds of claims just from private employers. The one thing I will note, and I'm not an expert on this at all, but I've looked, and that Religious Freedom Restoration Act does specifically apply, and the way courts have tended to interpret this, as my understanding, is it only applies to governmental actions and not an action between private employers. So just because, you know, the local store owner doesn't believe that doesn't like LGBTQ people for religious reasons, I think there's going to be some very interesting and difficult issues to claim that act allows them to then discriminate. But again, courts have been much more favorable to these religious freedom views. And certainly the Texas legislature, if there's ways to craft around it, I expect that Ricardo and a lot of folks will be seeing these types of carve-outs.
Yeah. I would say we are paying attention to what potentially will come down the pike. I don't want to get into specifics as to what, because I don't want to give our detractors some fuel or ideas of how they should come after us next, right? I'd much rather focus on being prepared to defend. But if anybody wants to know, like, there are webinars of what we foresee is coming down the pike in the Texas and the 87th Texas legislative session. Not that that's going to be federal, but it definitely, we know what we've seen and what are trends across the entire country in other state legislatures.
So Gary, to answer your question, I think you're absolutely right. I think that it's going to be that tension between fundamental rights and equal protection and religious liberties and free speech. And you saw that after Obergefell with, for example, Masterpiece Cake Shop. And there are folks who really truly believe in religious liberties. And I don't think that there's any reason not to, but there is a tension there between when is it that you get to exercise your religious belief, and when is it that that belief in exercising it goes too far and infringes upon someone's fundamental rights, or people get treated differently, so it would be a violation of equal protection.
Yeah, I agree. And, it's not like this issue hasn't been visited before. Back when the Civil Rights Act was passed to try to stop segregation, the famous case is Piggy Park. And Piggy Park was a restaurant in the South, and the owner of the restaurant said, segregation is part of his religious belief. It's a very core tenet of his religion that the races shouldn't mix, and he shouldn't be compelled to seat African Americans in his restaurant because that violated his religious belief. And that's the Piggy Park case, because that was the name of his little restaurant, his barbecue stand. And that went up to the Supreme Court, and the Supreme Court would have nothing to do with it. They said, no, your personal religious beliefs will not trump our civil rights laws in the public domain. And to me, that sort of should have answered the question. And I'm bothered that we're going back and sort of having these same questions again. I'm a bed and breakfast inn. I don't believe that two men should sleep together, so I'm not going to let you rent a room at my bed and breakfast. Well, in my mind's eye, that's no different than Piggy Park. And we shouldn't even be having to go to the court again on these issues, but it looks like that's where we're going to be going.
So Texas is one of 5 states that has no public accommodations laws, which cover restaurants, hotels, and places like Cowboy Stadium, so places of amusement, concerts, and whatnot. And so unless you're in one of the few cities in our state that has a non-discrimination ordinance, El Paso, San Antonio, Fort Worth, Dallas, not Houston. Houston's the 4th largest state in the United States. No non-discrimination ordinance. If you're not living in one of those cities, which is, so we only have non-discrimination ordinances that cover less than 1/5 of our population in this state. So that would be for housing, employment, and public accommodations. So you're right. I mean, that's there, and that's an issue. And Ricardo and I had a quick conversation about this before we got on the phone, and maybe Ricardo, you might chime in on what we talked about with respect to local non-discrimination ordinances. And I could talk more. They don't have any teeth. They're not very good. They don't provide a private cause of action. They have short statute of limitations, and they have civil penalties to businesses of up to $500. That's not enough.
Yeah, I think Shelley and I had talked about just that there has to be readiness, right? You have to be able to weigh your decision on advocacy moving forward and be strategic and transparent about your efforts and know that you have the support. So oftentimes you'll see organizers try to begin a movement without trying to power map or without trying to be strategic about what you're looking to achieve, who you need to influence, and how long that may take before change can occur, right? And how change can live over time and sustain, right? Because in order for change to be made, it also needs to be sustained. There has to be a plan for implementation and sustainability over time, right? And so what you want to do is create communities where change is possible. And that doesn't happen only because you're going to get something on a ballot, right? That's not going to change very much if you don't, and that can be overturned very quickly if you don't necessarily have the community support and the advocates locally to continue fighting beyond that short-term win.
I also want to just jump in and say that in Texas, the laws that didn't protect LGBTQ employees also, it's not only just the laws, but then the combination of the judges that have been interpreting them over the years. I mean, we have to fight really hard to protect African-American employees, people with disabilities, sex discrimination. These are very real issues in the workplace, and the laws in Texas and the way they've been interpreted by Texas courts, it is, I mean, again, I don't want to be negative, but we have a lot of work to do. And if you're fighting just for the rights of regular working Texans, I'm just here to tell you that it's a tough fight. And so as we're looking at these laws in these areas, 15 employees is the norm in Texas, but there's a lot of states that apply these non-discrimination laws to much smaller employees. Sex discrimination, the Texas Supreme Court has come up with some of the worst, they've come up with some of the worst decisions in interpreting what is sexual harassment and hostile work environment. I'm just constantly amazed sometimes about how the courts put up these barriers to enforce these discrimination laws. And so it's a lot of work for working people to try to make it a more fair place where you can actually be judged based on how the job that you do, and not the color of your skin, your sexual orientation, your sex, all these issues.
So
Well, there
just
is a
one,
lot of work to do yet. And
let me say one thing, Gary. Just 39% of our LGBT people of color in our state live underneath the poverty line. That's not acceptable.
yeah. And there is a lot of work yet to be done. And I think one of the important takeaways from this is not to, let's celebrate, let's enjoy this incredibly impactful victory that will give us a huge tool as we continue to work on these other legal issues. But let's have our little glass of champagne today and get back to work tomorrow. We're over our time by quite a bit, so we should go ahead and wrap this up. But I did want to thank my panelists so much. Thank you, Shelley, and all the hard work at Lambda Legal. Thank you, Bob. I know I've referred plenty of LGBT clients over to your office because I know you always take good care of them. And thank you so much, Ricardo, for all the work you are doing there at Equality Texas. And I look forward to being down there testifying this next legislative session. So and I'm sure y'all will do some good work in getting that all organized. So thank you. Thank y'all all so much. And
thank you, Gary.
Good work, everybody, for all the hard work y'all been doing. Have a nice evening.
Thank you.
You too.